In my professional practice, it's very interesting to see how even in some of the higher levels, certain judges that I've been before or heard of cases before, they still need a lot of education about how we have our families, particularly when there's a surrogate mother involved. I think the discussion about surrogacy and the ethics of surrogacy, which it's probably a more hot-button topic in Europe than it is in America. We have different patchwork laws here in America, and surrogacy is governed by state law. There have been cases in New York particularly, and New York is odd because New York surrogacy is illegal. Compensated surrogacy is illegal in New York. For instance, I have clients who have a compassionate surrogate in New York, but they live in New Jersey. So their adoption will take place in New Jersey, but they need to terminate the rights of the surrogate in New York. New York, the family court judge in Manhattan had clearly never seen anything like this before. And she was very concerned about the egg donor's rights, but the egg donor was an anonymous egg donor who'd surrendered her parental rights when she made the gamete donation at the clinic. But the judge didn't understand that. And it was very interesting because I was taken aback a little bit because I had just kind of assumed a New York family court judge would have had exposure to our families in a way that she clearly hadn't. It's very interesting to see how education and honesty about your family situation really does inform the people who need to be informed. And now there are programs for judicial education around second parent adoption and around families through surrogacy. And there's legislation now in New York to make compensated surrogacy legal. The one thing that is changing faster than anything is family creation and family protection. There was a case that was just decided at New York's High Court called In the Matter of Brooke S.B., and it overturned a case called Allison D., which was the worst case for gay families, mostly lesbian families, because it said that if you weren't a biological parent or an adoptive parent, you didn't have standing to go to court to sue for custody or visitation. So a couple would have a child together, they would break up, the biological mom would take the child away from the only other parent that they had known since their birth, and that other parent could do absolutely nothing. And it was a hardline rule, and in the matter of Brooke S.B., they went back and they looked at the dissent in Allison D., and they basically pulled everything out of it and said, you know what, we need to get back to the basics. It really is about the best interests of the child. And is it really in the best interests of a child to take him away or her away from the only other parent that they've ever known? And they overturned Allison D. So now the law in New York is, if you agree on the conception of the child, if you have an agreement about the conception of the child, regardless of your marital status, regardless of whether you've adopted that child, the non-biological parent has standing to sue for custody and visitation. Now, what we're going to learn in the future is what exactly does that mean for lesbian families now? Do they still have to go through the adoption process? I would state that they would, simply because that case does not necessarily create legal parentage that is portable around the world. De facto parenthood is not in every state. It does not convey the rights that would be acquired through adoption. Say, a legal parent can put their child on their health plan at work, or there's intestate rights that attach when you've adopted a child, inheritance rights. Those questions haven't been answered. But things are changing really fast, and I think they're changing for the better.